Okay, everyone, we're ready to start our first panel of the of today's session. The judge mentioned several times that we are in the midst of the time of the coronavirus, and that's of course why we're doing this by webinar and not live at John Jay College campus. What we'd like to answer in this particular panel is how the pandemic has impacted the policy changes that were done in the 2019 law and the 2020 amendments to bail reform. To take us through that, we have Steve Zeidman, our moderator for the session, who's a professor at CUNY School of Law and director of the Criminal Defense Clinic. You can read his full bio on our conference page, as well as other resources that we have for the conference. I should only mention that Professor Zeidman is a member of the Appellate Division's Indigent Defense Organization, and he serves on the board of directors of Prisoners Legal Services. He was recently appointed by District Court Judge Shira Scheindlin to an advisory council created to help implement her remedial order in the Floyd versus City of New York stop and frisk litigation. So I'm going to hand the gavel over to Steve. Welcome, Steve, and welcome to the other panelists. We're going to go for about an hour and 10 minutes or so, and in between that, we'll stop about 15 or 20 minutes short of that for Q&A from our attendees. Thanks, Steve. Over to you.
Okay, thank you, Steve. Good afternoon, everyone. Glad to be here. It's my pleasure to serve as a moderator of this panel titled Pretrial Detention in the Time of Coronavirus. Just a remarkable title in and of itself. Last week, the panelists discussed the bail system and racism, bail reform, the amendments, subsequent amendments to the amendments. And those of you who listened, and I guess there is some basic familiarity that a lot of you already have, the motivations for reforming the laws, the reforms that were enacted, the pushback to the reforms, the rollbacks of some of the reforms, the data or lack of data as to the impact of all those reforms to date. Our task today is related but different, because when the recognition that countless people were in pretrial detention, local and city jails, simply because they didn't have enough money to buy their freedom led to increased calls and pressure to eliminate money bail. At that time, none of us had heard of COVID-19. So now, added to the mix of all these issues surrounding bail and pretrial detention is concern about a lethal coronavirus. And I have to add, I really do want to start with this. It is really a serendipitous time for this panel to be talking about COVID-19 and the criminal legal system, as just yesterday, the New York State Senate, for the first time, held hearings about the impact of COVID-19 in state prisons on prison staff, incarcerated people, and associated families and communities, and asked what questions the Department of Corrections has taken, should have taken, must take to protect people from COVID-19. And I think today's panelists can give us their insights about how the bail reform changes, how coronavirus, how does that affect policing? How does it affect prosecuting? How does it affect defending? So we're fortunate to have with us panelists with extensive experience in different pieces of the adjudication process, again, from arrest to prosecution to defense. So let me briefly introduce each speaker. Craig Apple Sr. began his law enforcement career in 1989 as a correction officer for the Albany Sheriff's Department. 1991 became a deputy sheriff and subsequently served in the investigations unit. A few years later became a patrol commander, later the chief deputy field commander, where he led the law enforcement division and was responsible for oversight for the Albany County Correctional Facility. In 2009, he was promoted to undersheriff. 2011, elevated to sheriff. Welcome, Sheriff Apple. Wesley Caines is chief of staff at the Bronx Defenders, a nonprofit public defender office, and oversees the organization's systemic reform efforts. He's a graduate of Bard College and New York Theological Seminary, and his life's journey has enriched him with a perspective on the importance of human connection and community engagement. Welcome, Wes Caines. John Flynn became the 41st District Attorney of Erie County in 2017. He attended Bowling Green State University, joined the U.S. Navy after graduation, thereafter attending and graduating from the University of Buffalo School of Law, all the while continuing to serve in the Naval Reserves as a judge, advocate, Navy attorney, and a special assistant U.S. attorney. subsequently became an assistant district attorney in the Homicide Bureau of the Erie County District Attorney's Office. And before running for public office, District Attorney Flynn was also, I believe, in private practice. So a full range of experience that all of our panelists have. So I've asked each panelist to begin by addressing the same question. How, if at all, did the changes to the bail laws affect your office's work? And by that, I mean the policies, the approaches, any data analysis before the pandemic. So in that 4-month period, and then how, if at all, have things changed in the face of the pandemic? So let me begin both in alphabetical order and I guess in the way things progress with Sheriff Apple.
Good afternoon, first of all, and thank you for the invitation to participate. So how did it affect us prior to the pandemic? It had a drastic impact on us. A lot of changes needed to go into effect very quickly. The bail reform was one portion. The discovery portion had a greater impact, quite honestly, as far as getting our paperwork together, getting all of our data pulled down from body cameras to in-car cameras to 911 recordings, everything, and getting it over to the DA quickly so he can then in turn move it forward into the defense. So that had a big impact on manpower. We had to move police officers around, a lot of our civilian staff around. As far as the bail reform itself, it didn't have a drastic impact on the agency per se, because I mean, basically everybody was getting appearance tickets and released. And we had people that would normally, without hesitation, I'm sure, that would go into pretrial incarceration were released on pretrial supervision. And in many occasions, unfortunately, we were arresting that person sometimes hours later, or maybe a couple days later for another offense, and repeat the situation again. So, and I'm in favor of bail reform. I believe bail reform needed to take place. I just don't think we needed to, throw the baby out with the bathwater all in one shot. I think we needed to sit down and have further discussions with it. I know there was a lot of talk about law enforcement, DAs, everybody having conversations with lawmakers. I know that the Sheriff's Association did not have any, and I know that the Chiefs of Police Association, they said they didn't have any. So we're not sure who did in fact have any conversations. And I think it could have been done in a way where everybody agreed. And listen, we all want public safety. We all want the public to be safe. We're in the business to protect people. I'm not in the business to have a high census at our county correctional facility. And I'll mention that real quick. Prior to bail reform coming into play, we've worked really hard to lower the recidivism and to keep our census low. We're not a huge county. We're a little over 300,000 in the capital county. And at some point, we had 900 to 1,000 incarcerated. And I think that's a pretty sad number if you look at it. With that said, we've worked very hard over the last 7, 8, 9 years to lower that. And right around January, we were looking at a census of about 400. It did take a small dip when a few people were released through the months of January and February. It has taken a very slight uptick, which I don't think is uncommon with the amount of violence that's happened in many of our larger cities in the state. But right now, as I sit here talking to you, my census at the county correctional facility is 290. So in essence, we're at 29% capacity. Of that 290, 80 of them are not ours. So that puts us down to 210 Albany County inmates out of 1,100 cells.
And Sheriff, if I could just jump in there, what do you attribute that drop to? What would you say is the primary reason for the drop from close to 1,000 to 200?
Well, again, I think it was several years in the making. I'm not going to credit bail reform with it. What I'm going to credit is with a lot of the alternatives to incarceration that we've done in conjunction with our district attorney's office and probation and OCA. We have a lot of great programs in our facility, many of which were first-time programs, medically assisted treatment. We were the first county jail outside of New York City to offer that. That helped our SHARP wing, which was our Sheriff's Heroin Addiction Recovery Program. We were able to lower recidivism exponentially. We have a veterans pod where we got our veterans pod down to 5.7 as far as recidivism. Those are just crazy numbers. But again, I try to tell everybody we're in the business to help people and support people, not just arrest people and abandon people. And I think that's kind of the reputation that we've been able to have out here in Albany.
And post, with the outbreak of the coronavirus, have there been any, I'm imagining a scenario where maybe, in particular, a minor offense, someone might think prior to the coronavirus, this person's going to go through a particular process, but now you know what, it's sort of like a thumb on the scale. I just as soon, either I don't want to come into contact with this person or put this person in contact with others. Maybe I will just, give them a warning and say, hey, go about your business. Or has there been any sort of change in light of the coronavirus?
Well, I think it's safe to say that, law enforcement in general we became somewhat reactive. A lot of our proactive community policing, things like that, had to go by the wayside during this whole pandemic. And we're still very cautious out there, although, we're seeing the larger groups attend, like we had a function here in the city that, it's varying numbers from 700 to 1,500. We don't know what the real number is, but people are becoming less cautious. And needless to say, you can see a little bit of an uptick in the cases, in the positive cases. But we were giving a lot of warnings out. I think vehicle and traffic kind of ceased for the, for the enforcement. As far as our corrections, I can't praise them enough, the men and women up at the county correctional facility. We've had one positive case, and I still don't believe it was a positive case, although it did come back twice as positive. Nobody else tested positive, and we continually do testing, no staff, no other inmates. And that was it, because we set up a regimen early on, actually March 2nd. I think the first case was March 1. Immediately after that, we set up a cleaning and disinfecting, quarantining new arrivals. So they've done a remarkable job up there to keep it out of there and to keep people, the staff, and the inmates safe.
So everybody who's brought into custody is tested for the COVID-19?
That's correct. We actually just purchased a rapid testing machine, which will make life a lot easier for us, and then we pay a small fee per test. But they're also segregated for 14 days. We keep them. We're a large enough facility, and our census, as I mentioned, is very low. So we're able to segregate people away from the general pop until they get through 14 days, and then merge them back into general pop with their classification. So we've had to change a lot of programming. Those are some of the downside of this whole COVID as far as corrections, where people are not getting the counseling that they need. They may be not getting the mental health counseling, the addictions counseling, things like that. But we're able to, as soon as we get them out of the facility, we also run a homeless shelter attached to our correctional facility. So those who have no support system on the outside, we're able to transition over to the homeless shelter and make sure that they're getting the services that they so desperately need.
Thank you. Yeah, that reminds me of one of the things that was testified to at the Senate hearing yesterday. And obviously we're talking about state prisoners, a very different situation, but the problem with restarting programs and bringing people into the prison is just sort of a tough nut to crack. But thank you, Sheriff.
We still have not gone back to visitation. We're still doing video visitation. What we've done is we've given it to all the inmates free, and we give each inmate an actual $5 credit towards the commissary because they're not having that contact on the outside. So we're trying to just give them a little bit of leeway. So it's been, again, the staff up there have done a tremendous job controlling the situation, keeping it out of there. And, it's just a real fine line.
Thank you. And District Attorney Flynn, how are things up in Erie County?
Things are well. It's a beautiful day here today. Sun is shining. It's not snowing.
God, thank goodness.
Thank you. Thank you for having me here. I appreciate the invitation. I appreciate the opportunity to talk about, what I believe is some of the most significant criminal justice reform measures that have been passed in this country. And I'll start off by saying, I will echo the sheriff's comments that I am and was and still is a supporter of bail reform. we kind of have a similar story here to Albany County in the sense that our numbers went down dramatically before actual bail reform was initiated on January 1st. After I took office in 2017, obviously I studied the entire office. I studied the entire criminal justice system here in Erie County. And about a year or so into my term here, around the summer of 2018, I made a policy decision here in Erie County where I told all of my assistant district attorneys to no longer ask for bail on misdemeanors and low-level nonviolent felonies unless there was a good reason. And I put that quote-unquote good reason into their hands. Obviously, I gave them discretion on what a good reason may be. I articulated some examples. Obviously, as we all know, there are a number of domestic violence charges that are misdemeanors, unfortunately. And so if there was a domestic violence situation where an individual violated an order of protection and therefore violated a court order, in that regard, my ADA had, the full authority from me, to ask for bail in that case. But as a general policy, my attorneys in this office stopped asking for bail on misdemeanors and nonviolent felonies in the summer of 2018. And in the summer of 2018, I can tell you on August 1st, 2018, we had 1,074 people who were in pretrial confinement. On January 1st, 2020, when bail reform started, so the first month that it started, we were down to 425. So we had decreased the number of people who were in pretrial confinement by over 60% before bails even started on January 1st. So the reality is that the bail reform really didn't impact our office at all come January 1st, because we were already there. The only difference being, obviously, is that now my ADAs no longer had the ability to ask for bail for that quote-unquote darn good reason now. Because now, as of January 1st, all misdemeanors and nonviolent felonies, you couldn't ask for bail, period. Obviously, I don't like that. Obviously, I think that there should be some exceptions to that. But as you can tell from my overall policy, going back to the summer of 2018, I'm in favor of bail reform. I don't believe that people should be incarcerated pre-trial because they are poor and because they cannot afford bail. And like I said, we instituted that well before January 1st, 2020. Since we've kind of got back up and running here, there's been a slight increase in the number of folks who are in pretrial custody. On September 1st, we had 492. But I can tell you that the number from January 1st to September 1st has been in that 400 range. So in my opinion, we've bottomed out, quite frankly, I believe. We're never going to get below 400 probably, all right? The 400 range is probably the bottom out here in Erie County because all 400 of those are, individuals who have committed violent felony offenses who are justifiably in there as they should be.
Let me ask you, what's interesting about that too is it shows the influence and the authority of the district attorney's office. Because
I agree.
It seems like the drop was, there have been studies, I know there was one in New York City several years ago, looking at what is perhaps the most important factor in determining whether or not a judge sets bail, and it seemed as if it was whether the prosecutor requested it. So obviously, I think, kudos for driving down the pretrial population in Erie County. I'm curious, though, with to the extent that your assistant district attorneys have discretion, in the era of COVID-19, if it's an older person or someone you have some reason to believe has some sort of comorbidity, is that any sort of thumb on the scale as to whether to request bail or not? Like, I'm trying to figure out how, if at all, has COVID-19 impacted pretrial decisions in your office?
Sure. Okay, so the reality here in Erie County and again across the country, not only the state, was on March 16th when Governor Cuomo pretty much shut everything down. All right, the only proceeding that was open were arraignments. That was it. Everything else was shut down. There's no more felony hearings. There's no more pretrial conferences. Obviously, there was no grand jury. There was no jury trials. There's still no jury trials here in Erie County as of right now. So the reality was, Steve, that everything shut down in mid-March, except for arraignments. In about a month or so into the pandemic here, I'm going to say probably around Easter time, Passover time, mid-April there, we opened it up to bail applications. All right, so we started having, we got together with the public defender's office here, and we started, first of all, we had to convince the courts to schedule bail hearings. All right, so we got that. We got that done, and then we started to look at these 400 or so people who were incarcerated. And we, again, we encouraged the defense attorneys, the legal aid and the public defender's office here to make bail applications on those who were at a high risk for catching the virus. So those who may have had pre-existing conditions, heart problems, diabetes, older age, whatever the case may be. And so we started having these bail hearings, and we started to evaluate whether or not we could perhaps either lower bail on this individual or agree to release. Now, I'll be perfectly honest with you. I didn't consent to a lot. I'll be perfectly frank with you, okay? Because I did do a few, and a few did get out, all right? But I put it this way. We also, in order to alleviate the conditions at our jail facilities here, we also reviewed sentenced prisoners here in Erie County, where I ran a list of individuals who had 45 days or less on a sentence, okay? And then defense attorneys made a motion on letting them out early, okay? Albany County did the same thing. Actually, I stole that idea from David Soros, okay? I think Albany and Erie were the only two counties in the country or in the state that did this, all right? So the reality, Steve, is I let out more prisoners, more sentenced prisoners who had 45 days or less than I did consent to people getting released on bail. Because the reality is that, like I said, with the 400 people that I have in pretrial confinement right now, 90% easily are people who are in there for murder, robbery, shootings, rape, whatever the case may be. And again, if they had diabetes, I'm sorry, I wasn't going to let them out. You know what I mean? So, a few did get out, and we did, I did encourage bail hearings, and we did have these hearings. But again, to be perfectly honest, I did consent to that many.
Thank you. Thank you, District Attorney Flynn. Let me now turn to Wesley Caines and the perspective of the Bronx defenders and how the bail reform and the reforms to the reforms affected the practice, but then also how has coronavirus, how has concerns about COVID-19 change the public defender practice? What efforts are public defenders making? And I say this in the context of, again, I keep hearkening back. We heard testimony yesterday at these Senate hearings from people who had just formally been released in the last 2 months from state prison. And they talked about the inability to control their bodily movement because they were incarcerated, so that they could not maintain social distance, that they lived in fear every day because every time they left their cell, they were surrounded by other people. And so the question was, what efforts can advocacy organizations make to try and extricate people from that precarious situation? So Wes, tell us about the Bronx Defenders.
Sure, thank you. Thank you for having me here. Great hearing the sheriff and district attorney speak around bail reform and discovery. I want to speak from the perspective of, the Bronx Defenders, and, our office does, prior to the bail reform, a lot of decarceration work. And we did that decarceration work around the value of shrinking the footprint of, government systems, as particularly it intersects with race, class and poverty. And, what we have found in our work is that the things that had necessitated bail reform are the things that got lost in the effort to roll back those reforms, right? It's the things like the discovery that the sheriff mentioned being a challenge to really, get up to speed in implementing that. Well, that was a challenge for public defender offices, district attorney offices, as well as law enforcement agencies, right? But being a challenge doesn't mean that it wasn't the right thing to do. If you can imagine, at least in New York City and in the Bronx, most criminal transactions that end in some adjudication process ends without people ever having access to the evidence or witnesses against them, right? They take pleas overwhelmingly blindly. And there's something fundamentally wrong with that. When you talk about the power of a district attorney's office, even in the efforts of DA Flynn, advising his ADAs not to ask for, bail for misdemeanors, barring some self-identified good reason to do so, that's an enormous amount of power to place in the hands of a district attorney, right? And in the case of New York City and the Bronx in particular, what we have seen over the years is bail and pretrial detention has become this coercive measure that is used to incentivize people pleading out. And I know the narrative has been around safety and public safety, but that was really never, ever the issue around bail reform. The charitable bail funds were able to get into this game and bail misdemeanor detainees out of jails in New York City and develop the data to not only show that when people are released for pretrial reasons, they show up to court overwhelmingly. Second, the outcomes of those transactions in our court system far more benefits the defendants than if they were detained, right? So at least in New York City, bail became a way to really, advance the transactions in our criminal legal system. And there's something fundamentally wrong with that. But what we have seen since the advent of the reforms that went into effect January 1st, and I must agree with DA Flynn in that most of the district attorneys in New York City preempted implementation of the bail reform on January 1st. Many of them in November and December leading up to January began to not ask for bail, and folks charged with low-level offenses that would be captured by the implementation of bail reform were being let out without bail being set, and people were coming back. However, what we saw in the rollbacks was a really, frankly, begrudgingly smart weaponizing of the media in pushing a narrative of public safety at risk because every person or more people who, are arrested are not being caged and detained prior to an outcome of their case. And if you unpack that and you think about someone who's held at Rikers for 2 weeks, which oftentimes pre-pandemic was the amount of time, 2 weeks to a month and a half before they took some low-level plea, which then allowed them to return to the community. Those individuals were never a danger and arguably should never have been detained, right? But there was a very smart effort that was undertaken when the bail reform rolled out, which led to the rollbacks. And this was devoid of any data to demonstrate unsafe streets. It was devoid of any facts around, the bail reform inherently being a bad thing. It just became, a talking point for folks who in the media did not like that they weren't able to control and tip the scales in favor of law enforcement and the district attorney's offices. Ironically, with the rollout of the reforms in January, it did change a lot of the work that we do in our criminal defense practice, right? Those misdemeanors became DATs. To the DA's point, those desk appearance tickets meant that we were engaging and connecting to clients in a very different way. No longer were we meeting clients at arraignment in the same way as pre-rollout. But the pandemic really showed for me the hypocrisy of the rollbacks to the bail reform. In New York City, we went from a census at Rikers of approximately 6,000 people before the lockdown and before the pandemic really hit New York State very hard, to about 3,800 by the end of April, right? And that drop really demonstrated that there were many people who were incarcerated who arguably should not have been incarcerated. One of the things that we have seen is that there have been an uptick since the end of April, but we are still far below that 6,000 number. Right now, we're at about 4,300 people at Rikers, and the vast majority of whom are detainees, approximately 2,000 plus. But many are people who are held on technical violations, some of whom have state sentences and are awaiting transport to the state system. But our work has really been, during the pandemic, heavily weighted towards advocating for the release of those people who, one, are serving city sentences, two, who are detained, who do not represent a risk to public safety. And in fact, the data has shown that when people are released and given support as simple as a reminder of a court date, people return to court. I think another challenge that we now see that's taken place since most of the court operations have gone to remote work is that some people lack connectivity and the technology to access the courts. So we as public defenders are having to bridge that digital divide between our clients and their day in court. And I might add, for a lot of these, at least in New York City, I'm not sure how this works in Erie County, but most of the appearances in New York City are just performer appearances. These appearances, there's no decisions being made. It's simply, an appearance on the record and a rescheduling. And thankfully, most of that at this point has been happening remotely. But to the DA's point, we're still having arraignment and a limited amount of in-person appearances now, which are literally calendaring to recalendar, to be adjourned and recalendared as a later date. And most of that was really, again, behind the very smart public relations arguments that have been made about courts being closed and, criminals, quote unquote, are running the street because our courts are closed. And those comments have come from a mayor and police officials who know better, but yet feed a frenzy of misinformation in the media. The courts have never closed. They were never closed. Courts were still functioning. They were functioning remotely. And, I want to acknowledge our local district attorney who has made that argument on several occasions and pointed out the fallacy of the notion that the courts were closed, and it's a product of the court closures that's driving uptick in any offenses in the community.
Yeah, it certainly seemed like the courts became very quickly the target for a lot of officials in one form or another. But let me just take a couple of things that you've said and go back to Sheriff Apple and to District Attorney Flynn. And I hope this is on point. I'm wondering, again, I'm going to try and focus for the next few minutes before we get to Q&A on the impact of the virus itself. And trying to imagine from law enforcement's perspective, it sounds like already in Albany County, there's a heavy use of diversion programs or those sorts of things. What do you see as the best possible law enforcement responses to the virus, to fears about the coronavirus when people are arrested from low-level offenses to more serious crimes?
Well, we take a lot of precautions, obviously. We're constantly, in Albany, we're a little bit different where the sheriff's office oversees emergency management. So we've been able to basically just blend everything from corrections to law enforcement, emergency management. I mean, we've given out like something around 1.3 million pieces of PPE. So we've done a lot. There are some fears, and we're not in the business of filling the jail. I'd like when the vacancy sign is on. I'd like to see the empty sign on. Unfortunately, there are bad people, and we know that, bad people are going to remain in jail. And, unfortunately, many of these younger bad kids that are involved in the shootings and everything on our streets today, sadly, I'll see their names for years and years to come. But we haven't had, there was similar to what Mr. Caines was indicating with the court shutdown. Many people were saying that the police shut down, that the police weren't on the streets. Unfortunately, you live within a bubble, and people inside the bubble know the truth, that the courts were always operating. I spoke with our DA just about every day of the week. We were able to make some really great progressive changes in our system up here as far as video arraignments and the use of technology that we've been begging for 10 years. And the police never shut down. Yes, we were being very cautious. Yes, we may not have been going out and, and doing community policing and walking beats and shaking hands and giving hugs. But you know what? We were always out on the street. We were always answering our calls. It's just a very cautious time. And the last thing that we want to do is see an uptick in the amount of positives, which sadly is starting to occur with the opening of the schools and the colleges. And it's something that was somewhat expected. But we've always been here. We're always going to be here. I know a lot of people in the public were like, oh my gosh, the police aren't working. They're not leaving the stations. We never gave anybody time off. We never had people request time off. We had very few cases. Sadly, I did have a positive almost immediately, and it rocked my world because I'm like, oh my gosh, I've got a positive deputy. We had a funeral for an officer. That positive deputy was in a car with 5 others. I'm thinking, oh my God, this thing's going to run right through our department. And it didn't. It was controlled. And that was within the first week. So we learned a lot from that. And we also learned to stem some of the fears. But again, it's just taking the proper precautions and, just encouraging and educating people on the use of the PPE as well will save a lot of lives.
Mm-hmm. And I'm going to turn over to District Attorney Flynn and wondering, the changes that you implemented prior, I guess you said that was in 2017 and 18, as early as a couple of years ago. Do you see these sorts of, well, let me just put it directly. I think that Erie County is fortunate that you implemented those changes, but by the same token, without legislation, another district attorney could have a different view. And I'm wondering how do we, short of legislation, make these sorts of important changes long lasting? In particular, in the COVID era, when I think there's a heightened urgency to have fewer people incarcerated.
Yeah, I agree with that, Steve. I think that there needs to be a recognition that because there are not as many individuals that are being held pretrial, that doesn't necessarily mean that there's more crime. And again, I know that there have been some individuals who are linking the increase in shootings and homicides that we're seeing statewide to bail reform. And whenever I'm asked about that, I'm very cautious, and I tell people, and I'll tell this panel right here, everyone listening, all right, that you cannot make that leap right now, all right? First of all, the reality is that there's no data out there that supports that at all. So anyone who says that the increase in homicides and the increase in shootings is a direct result of bail reform, I don't believe that, for one, okay? And two, there's no data to prove that. Like I said, the reality is that we really only have 2 months of data to deal with, January and February. All right, I get Wesley's point that courts were never shut down, but again, the reality is that the only thing that was open were arraignments. Okay, I mean for a while there. Okay, so while I agree with Wesley, the courts were never shut down. 95% of them were. I mean, all the functions of courts. So fortunately, here in Buffalo, we never had that narrative that the courts are down and crime is on the rise. Okay, that narrative never came to Buffalo, because the reality was crime went down dramatically during the virus here in Buffalo. All right, I mean the only thing that rose, unfortunately, were shootings and homicides. Everything else went down dramatically, crime-wise here in Buffalo. April, May, June even, starting to tick back up in July. But our arrest numbers right now are still well down from what they were in August, September of 2019. So again, going back to your point, Steve, going forward here, we have to disconnect the narrative that's out there that if you have less people incarcerated on bail, that crime is going to rise, because there's no link to that at all, at least right now. And so the more you say that, the more you confront the opposite message. I think that's much better for the criminal justice system going forward.
Thank you. And I'm getting a heads up that we have a couple of questions, so I want to be sure to get to those. So Stephen or Michael, one of you want to address those questions?
Hello, sorry about that. Yeah, we have quite a few questions. We had one from earlier on. I think this was for Sheriff Apple, but if any of the panelists want to take it. The question is, you mentioned a number of mental health and substance abuse services available in your jail, but do you think it would be better to divert people who need those services out of the criminal justice system to be treated outside of jails? Also, do you think that there is a racial or socioeconomic disparity in who gets treated inside or outside of jail? In other words, are wealthier people sent to a rehab facility instead of jail?
I can take a crack at that. I think there was a little bit of disparity on the outside. I can certainly say not on the inside. Inside, I've always said, I think it's kind of sad that you need to come to jail in order to be treated for addiction or mental health disease, whatever the case may be. But I also know that we do a good job at it, and we've been able to save and change a lot of lives in Albany County as a result of the services we have. Do I agree with having to go to jail to get those services? No, I think there should definitely be circumstances on the outside and diversion before you get to me. But with that said, it wasn't happening. And that was one of the reasons why we started a lot of these programs. And with that said, I also, when bail reform came in, I lost an opportunity to help a lot of those that were afflicted with addiction. And what I mean by that is that I would get many calls from moms or dads asking me, hey, my daughter is over at Motel 6. My son is over here under the bridge, whatever. Can you go and get them? And, he always carries, can you get him into your system? So, we would even confer with the district attorney's office. We would take them for something real low level, get them in just so we can get them clean, detox them and treat them, whether it was mental health or addiction, which both of them always blend and run together. So it was very hard for us because, again, I feel the frustration, and people would always, scream at me like, well, do you really think it's necessary for folks to have to go to jail to get those services? No, I don't think it's necessary that they have to, but I know that we can save and change lives. So I was always hoping that, give me that person, give me that daughter, give me that son. Everybody deserves to be, to get treatment and to be able to help themselves, and support themselves. So it was very hard, but I think there was a disparity on the outside, to answer that immediately, yes.
Thank you for that. Another attendee asks, how do you separate the impact of changes in pretrial release from the economic devastation caused by the pandemic on interpretations of the quote unquote uptick in crime? And that was for any of the panelists.
You want to take that, Wesley?
I'm going to leave that for the lawyers.
I'll take a stab at it. I think I'm just reading it again. Yeah, I think it's a challenge to make that separation between the economic downturn and I think the bigger challenge is for policymakers and for those who have a platform not to make those connections, right? I don't know that we have the data to show the impact of pretrial release and its impact with what this pandemic is frankly doing to people's financial situation. And I think that in the same way that I'm very skeptical of the connection between the pretrial and the violence that's taking place in the community being one that's not supported by data or enough facts, I'm also cautious to automatically assume that there's also a correlation between the uptick in the violence and the economics of the pandemic. Clearly there's a lot of things at play that I'm not a sociologist. I don't study social and economic conditions and the impact of pandemics on people's trauma response, how people respond. But I think that those of us who have a platform and speak with some authority from where we sit really have a responsibility not to shoot from the hip and make connections that we can't support, or to make connections that only advance a position that we have that's very short-sighted in my view. I think some of the narrative that has come out of our mayor's office and out of our police department in New York City clearly are uninformed comments that has made linkages that evidence is lacking in. But it's a challenge, and I think that when we don't know, we should just be comfortably saying we don't know.
If I can follow up with that, and maybe this will be more direct for the district attorney, recognizing the discussion about the arguments or the requests for bail reconsideration because someone was at risk from COVID-19. Let me ask that another way, which I hope picks up on that question. So let's say I'm the defense lawyer and someone's charged with a robbery, and I come to you and I say, how do you take into account the fact that this person, we just have massive unemployment, and so many people's families are affected. They've suffered loss, family members sick, people dying, and I'm asking you to take into account a pandemic that none of us have we don't even know how to factor that in. And the reason I'm asking it is I can imagine part of what you're going to say is that you always want to hear people's, explanations for what happened, but it seemed like this is beyond that. This is beyond saying, hey, I was unemployed, I needed something. This is a devastation like we've never experienced. So how, if at all, do you imagine your office factoring that in when you determine whether to request bail or how you want the case adjudicated?
I will definitely take it into consideration. Obviously, every case is different. I would have to take it on a case-by-case basis. Obviously, there are a number of, listen here, when an individual has a qualifying offense, all right, now we are able to, both sides are able to make arguments to the court on why bail should be put in place or why it shouldn't be. All right. So all the arguments that were made prior to January 1st, when everything was on the table, the person's history of coming to court, the person's a criminal history, the person's connection to the community, their flight risk potential, all these factors, that one could argue pre-January 1st. Don't forget, we can still make those arguments now on qualifying offenses, okay? And so the fact that we have a pandemic here that is the likes that we've never seen before, that has had devastating economic impact on the residents here in Buffalo. Those are factors that I will consider. And again, I continue to consider factors such as pre-existing conditions, and the person's age, and all the factors that go into the problems of people locked up in a confined place and protecting their safety, along with the safety of the sheriff deputies and the employees of the holding center as well. Like Albany, we only had one positive at all, knock on wood here, the entire time in our holding centers. And we have two here in Buffalo. And so one is pretty good, I think. One too many, but it's pretty good. And so we've been fortunate where we've been able to keep the safety of not only those incarcerated, but also of the sheriff deputies and the staff members there. So I definitely, Steve, will consider all the above, including economic factors as well in bail determinations.
Thank you. And let me just, I know there's a question, but I want to follow up with this. This is very sort of a nuts and bolts question. We're talking about pretrial detention, bail determinations, and typically, as is just what was described, you have a judge, you have a prosecutor, you have a defense lawyer, you have a person, the accused, right there in court, and the lawyer has met their client face to face. And right now we have a situation, I think, in most jurisdictions in this state where that is being done by video. And one of the questions that is already coming up is, when, if at all, is this going to change? Because we already know there is some talk that this is, quote, more efficient, saves money. And I'm just wondering your thoughts, both in the Bronx for Wesley Caines and also up in Buffalo, whether you believe that it is incumbent upon the court administration to go as soon as possible back into in-person arraignments so that these decisions are made right in front of a judge with everybody in the same room.
Absolutely. It's not only arraignments. We're doing felony hearings here virtual. We're doing a lot of court proceedings here in Buffalo virtual. And again, I probably can speak for Wesley here. We're probably on the same page here that I think it is imperative that a defense counsel is able to speak to his or her client and to engage in conversation and to have that one-on-one communication there in court. I think that is very important to our system. I recognize, though, that while the numbers may have plateaued here in Buffalo and in New York City, we're obviously concerned about the numbers spiking back up. We're concerned about flu season coming, and I can tell you that our court system is very hesitant to turn a switch back on. And that's not a criticism of the court system, but I can tell you that they're very hesitant to turn a switch back on. So I don't know how long this is going to last for, but I'm a big believer in getting back the way it was before, and I don't believe in a new normal. Okay, I don't want to wear masks for the rest of my life. Okay, I don't like masks. Okay, I want to get rid of my mask. I want to get back in court. I want to get back in person here. Okay, I don't want a new normal. All right, and I want to shake people's hands. I want to hug people. Okay, so everyone out there who's this new normal. Okay, you're not going to get my vote. Okay, I don't want new normal. I want to go back the way it was, and hopefully we get back there sooner rather than later.
Yeah, I don't know that I wanted to go back the way it was, but I totally agree that for due process to mean anything, people accused of offenses must have a meaningful engagement with their counsel. And that needs to happen in a way that doesn't factor in, unreliable technology and the like. But first and foremost, court spaces need to be safe, to the DA's point. Opening up courthouses just for the sake of having in-person appearances that are unsafe to, the people who work in those courts, the general public, defendants, and counsel, just doesn't make a lot of sense. So I think those spaces have to be made as safe as they can possibly be before there's any, brash movement back to in-person appearances. But what I would hope that the pandemic would have demonstrated to the court and to those acting within the court is the ways in which we ask defendants to show up in court with the frequency that they must show up in court. Oftentimes, with no resolution, everyone knows that there will not be a resolution to an appearance, but yet we appear on the record and then we adjourn until another date. And maybe the pandemic is an opportunity for us to look at those calendaring of cases when there's nothing substantial going to happen in a case that make us say, maybe let's look at the federal model where people are, charged, accused, charged, released, ideally, but even if confined, at least have a date certain when their case would move forward. And in between that date certain period, if there's certain negotiation between district attorneys and defense counsel, those things can happen without asking folks, especially folks who are, at home, who have to work, who have to deal with childcare, who have to deal with, other things in their lives to take a full day away and show up in a courthouse and not have a time certain to go before a judge, but oftentimes have to sit there for hours under quite restrictive conditions of no access to your phone, the inability to sleep or close your eyes for 5 seconds or longer. Like, you know, let's take a look at how we do court, and let's use this opportunity to re-examine that and maybe think of a better way of doing it.
Thank you. Michael, I believe there was another question that you have.
Yeah, thank you. And thank you for those answers. So I think this last one is to Sheriff Apple and DA Flynn. Do you believe that you have a responsibility to the community to make sure that your bail reform comments in the media are factually correct, that they don't add to the hyped hysteria?
I believe so. And I don't think that we've done anything to, you know, create fear mongering or anything to that effect. I mean, I see both sides of it other than the actual prosecution, which the DA can speak about. But I mean, we're on the arresting side, and of course we have the detention. So, you know, we have the numbers speak for themselves, and I've never really gone outside of that. I didn't want to give bail reform all the credit that people want to give bail reform, for the simple fact that it takes away from some of the great things that we've done here in the county in conjunction with the DA. And I'm glad that DA Flynn brought up the fact that our DA was one of the first ones that said, hey, listen, let's get some guys in here. We'll release, resentence and release. And, you know, he was out there doing that, you know, way ahead of, you know, the court administration ever thought of doing that. So I think that, you know, at least for myself, that I've always been straight up, and these were my opinions, not just opinions, but they were based on facts. Facts from our correctional facility, facts from our dispatching center, where we dispatch for, you know, a handful, actually up to 10 police agencies. So, you know, we have access to all the calls, all the arrests, all the data that's coming from, again, from the arresting all the way through the correctional setting, and then the prosecution stage.
Yeah, I believe it's very important also. I agree with the sheriff that, you know, what you say and how you present the issues to the media needs to be factual, and needs to be straight, needs to be honest. And, you know, you have I recognize the influence that I have, you know, getting back to a point that Steve made earlier, as far as and I think, you know, Wesley brought it up too, you know, the power and the influence that district attorneys have, you know, especially me, the elected district attorney, who is in the media a lot here in Buffalo. You know, a day doesn't go by that I'm not on TV or in the radio or in the paper. And so I'm cognizant of the fact that that's a fact and that's true. And so what I say and how I say it needs to be carefully crafted and needs to be factual and should not stir people up. With that said, you know, if I got an opinion on something, I know I'm going to give you my opinion. I think in the past hour or so here, you know, I think everyone can recognize I'm not shy, and I'm going to tell you what I think. And so if I'm asked about, you know, bail reform, and the changes that were made, you know, I'm going to characterize it differently. You know, Wesley characterized it as, rollbacks. Okay, I don't believe they were rollbacks. You know, the changes that were made in April of 2020, in my opinion, were tweaks. Okay, so I'm going to use the word tweaks, and others are going to use the word rollbacks. Okay, so and I'll be perfectly honest with you, I think more tweaks need to be made. Okay, so again, I'm not going to shy from giving my opinion, but with that said, I recognize that I shouldn't be stirring people up. I shouldn't be a part of fear mongering, and hopefully I'm not.
Thank you for that. And I'm getting the heads up that we have to wrap it up here. I'm going to turn it over to Steve Handelman, but I also just want to take a moment to thank Craig Apple, John Flynn, and Wesley Caines for giving us an hour of your time and the benefit of your expertise and knowledge. Thank you. Thank you all.
Thank you for having me.
Let me add my thanks to all the panelists and to Steve especially for moderating really, really instructive and useful panel. I do want to add that we did try when we were setting up this this session to enlist critics of the bail reform from all stripes, and we tried to get the NYPD folks in, but we really hadn't heard back from them. So in the interest of being as objective or as many-sided as possible, we did want to get a full range of ideas and perspectives about bail reform. We are going to go now into our next panel, which will take us to the end. We're going to be talking about putting the New York changes in the context of everything else that's going on in the country in terms of justice reform. I want to remind everybody that we have a recording of this panel. We're recording it. It's on the record, and we will, as soon as it's ready and up on our site, we will let you know so you have access to it. And once again, and I'm very sympathetic to DA Flynn's approach that he doesn't want the new normal. I think none of us really want the new normal. I'm not sure that we're ever going to have that wish. I'd like to think it's possible, but certainly considering where we are now, this panel itself was beyond the normal. It was super wonderful, and I want to thank you all for taking the time from your busy schedules to join us. We're going to take a 10-minute break when we get our next group of panelists on. I hope you fellows will stay with us for the rest of the session if you can. Thanks very much, and thank you, Steve.
Thank you all.
Thank you.